Hello, I'm Locke Meredith, and I'd like to ask you to join me on the next Legal Lines. We're very fortunate to have on the show Judge Jimmy Kuhn. He's a judge with the First Circuit Court of Appeal here in East Baton Rouge Parish. And we're going to talk with Judge Kuhn about what is it like to file an appeal, what is the process, what do the judges have to do, how do they do it, who helps them do it. And then we're going to talk about how overwhelmed the First Circuit Court of Appeal is and how long it takes to go through the appeal process. And are there any alternatives? We're going to talk about mediation and how that oftentimes resolves a case quickly and for a whole lot less money. So join us on the next Legal Lines with Judge Jimmy Kuhn. Welcome to Legal Lines. I'm Locke Meredith, and I'm very pleased to have on the show again Judge Kuhn. Judge is with the First Circuit Court of Appeal. He's been there for how long?
10 years, just re-elected for another 10 without opposition.
Time flies, doesn't it?
It does, certainly does.
And you ready to go 10 more?
I'm ready to go 10 more, or as long as I can walk, talk, and read.
Judge, thank you for being on the show.
I'm happy to be here.
We had talked a little bit about kind of the appellate process when you were here last time,
Right.
but our focus today was going to be kind of what is the job of the First Circuit Court of Appeal, how that's done, what resources do y'all have available in terms of people and the task and all that, and what alternatives are there, because as we were discussing, it can take 2 to 3 years to get a decision through the trial court and the appellate court, and it could still go up to the Supreme Court.
Very good question, and it's interesting that you asked that question. Frankly, I remember some 30 years ago when I started practicing law, for some reason or other had the impression that the Court of Appeal was just another shot, another trial. And as you know, that's not at all the case.
A lot of people think that.
They certainly do, and a lot of people practicing law believe that. But as you know, the Court of Appeal reviews the case to see if there's been an error made, usually an error in abuse of discretion that a judge may have, factual conclusions that judges reach to see if there's an error there, or if there's an error of law. We really don't retry the case, which puts a totally different perspective on it. Insofar as the resources available and what we do, we actually receive the record that comes from the district court, the trial court, and in that record it's whatever pleadings that have been filed, the physical evidence that's been introduced, and a transcribed, that is typed up record of the testimony. So word for word what's said in court is and should be in the record. And so what we do is review those, and then of course we review the attorney's briefs.
Which are their arguments.
Their position on the
spin on the evidence.
The facts and the law. And then we search that. The attorneys are required to tell us how they feel an error took place at the trial court, and we review those in an attempt to determine. What's fascinating, I think, and also the most interesting part about the court is the fact that these cases are heard by 3-judge panels. So under the Louisiana...
Why is that, Judge? We were talking about it before. It's a good reason.
It's an excellent reason because you get 3 independent views, as you should, of what happened with the trial court. And so each judge has their own staff, and they review the record and come up with independent ideas about how the case ought to be handled at the appellate level, confer, and then render an opinion.
And in addition to that, y'all get to listen to us lawyers come up and argue, have an oral argument in front of you.
We certainly
I'm not sure how successful that ever really is.
Well, it's interesting. Frankly, I like to ask the lawyers questions because it gives me an opportunity, after having looked at the record somewhat and the briefs, to come up with my own perception of what are the real issues in the case. And so sometimes I just want to know if there's something that happened in trial court that I can't really pick up from the record, and have the attorneys discuss that.
So to summarize, the appellate court's job is not to retry the case. It's to take the evidence and the law that was submitted to the trial court and review it. And it's not like what they call a de novo review, like you're sitting as the judge. You basically have a limited standard of review to see if an error was made.
That's right. There's some exceptions to that,
right,
as you know, but that's a good summary of the process.
And the process of that is an appeal is made by either the losing and or perhaps even a winning party saying, I want more money or something. And they have to file pleadings and file briefs, and all the evidence is, as you said, typed up and sent to the First Circuit Court of Appeal. And then your staff basically reviews it, organizes it, and ultimately, what does the judge do? Does the judge actually read all of that stuff, or does he give a synopsis from his law clerk? How does that work?
That, of course, depends on the judge. I like to read some of the stuff first. If I see something that is inconsistent in the briefs, then I'd want to look at the testimony in the record. And after that's done, I jot down some preliminary ideas about what I think the issues are in the case and how it might be resolved. The law clerks look at it, and then we discuss it if necessary. And I always expect them to look at it totally objectively from what I say. Don't necessarily agree with me, and I want to have a discussion.
A good debate.
Exactly.
And then each of the three judges, do y'all actually debate the issues?
What we do, frankly, at the First Circuit, there's very little time for this process, that is, to confer about it. But we do confer, and for example, if I'm writing an opinion, or proposed an opinion, which we call a report, I would write the report and then provide it to the other two judges, who then independently review it and then let me have their thoughts on it. So oftentimes that conferencing, if you will, is by email, or sometimes telephone, and sometimes personally.
Judge, how is it chosen which particular judge is going to author the opinion?
That's randomly selected and rotated.
So it's not someone says, I have a particular interest in this one, and so I would like to do it, or is it roll the golf balls and let them pop out?
That's exactly, rolling the golf balls, no selection process.
Interesting. And then the decision is rendered, everybody signs off, either agrees or concurs or dissents, and the decision is rendered, and then the appellates can take it up another level.
Well, as you know, in Louisiana, there's a right to an appeal to the intermediate appellate court, such as the First Circuit, my court. And then we call the Supreme Court a writ court, where anyone wanting a further look at the case has to make a request to the Supreme Court, and then they determine whether or not they get that additional appeal.
They don't look at it too often, do they?
Roughly, the Supreme Court looks at 80 cases per year to write opinions.
And how many cases do y'all deal with a year?
Our 12-judge court, per judge, anywhere from 65 to 73 per judge. So if you're on a 3-judge panel, you participate in a little over 200 cases per year for an opinion.
We talked about the quantity of appellate judges in Louisiana compared to other states. We have, what did you say, almost 60?
We have 54 or 55 in Louisiana.
And other states have as few as 12?
Yeah, in Mississippi, for example, there's only one appellate court. We have 5 in Louisiana, but Mississippi's population is dramatically less than Louisiana. But on the other hand, there are large states. I think it's Michigan has 12. But you know, there's
how is that possible?
Well,
why is there such a difference?
We have unique things in Louisiana. Either by statute in the Constitution, it's required that the appellate courts review the facts of the case as decided by the trial court, plus the law. And in other states, in every other state, there is no review of the facts. It's simply review for error of law, which makes the review of the record dramatically different. In order for you to review the facts in the case, you have to make sure you read every single word of the record, and this is mandated by the Supreme Court as well.
Judge, we'll talk about that on the next segment. This is Locke Meredith with Legal Lines and Judge Jimmy Kuhn with the First Circuit. We'll be right back. Welcome back to Legal Lines. I'm Locke Meredith, and again, very pleased to have on the show Judge Jimmy Kuhn. He is a judge with the First Circuit Court of Appeal. Again, Judge, thanks.
Happy to be here.
We're talking about basically how thorough you guys have to be, how time-consuming it is, and let's talk now about the quantity of cases that y'all have to handle, the population that you're dealing with in your district, and how that just puts constant pressure on you guys.
All of those facts create a dilemma for us, because the job, after all, is a job of public service, and it's so important. A court opinion can affect so many people's lives, and oftentimes we're confronted with interpreting the law, and the policy consequences of it are great.
And I don't think people understand that you might be deciding the facts of the law for that one case, but it affects thousands of other cases on how you determine that one set of facts.
Well, not only cases to increase my stress level, I look at it how it might impact people's lives.
Exactly. I mean,
so the job's incredibly important, and I have to say that the overwhelming majority of people who are appellate judges are very aware of that and very conscious and make every effort to make sure that every opinion is absolutely correct. And as you would expect, oftentimes it's very stressful. You combine that fact, that is, we want to make sure that it is precisely correct, follows the law, and we understand the impact on the citizens of Louisiana. When you combine that with the caseload at the First Circuit, there's a dilemma. And the dilemma is, how do we turn out cases fast enough so that people have their issues resolved and at the same time make sure they're absolutely correct? It's a problem.
You were showing me during the break a chart showing statistics. Discuss that.
Well, there's several statistics that are pertinent. The First Circuit, as you know, is 16 parishes, and we have within the First Circuit East Baton Rouge Parish. And as you also know, and I'm sure most of your viewers know, having East Baton Rouge in the circuit means that we also consider an enormous amount of government cases.
Because that's the seat of our state government.
Right. Civil service cases, Department of Environmental Quality cases, whatever it may be, election contest suits on statewide elected officials, and so on. So there's just a great volume of work. In 2003, including filings, and from filings I mean appeals that were filed and writs. And writs, as you know, Locke, are intermediate rulings of the trial court which affect how a trial may go forward. For example, if you have a murder case going on, the trial judge may tell the state, well, you can't introduce this confession, and the state has a right to apply for a writ, which is a sort of appeal where the Court of Appeal rules on that decision.
It says, help me now.
Right. And then, of course, the trial goes forward after we rule on it. So including writs and appeals filed in the year 2003, the First Circuit had 1,650 filings in that one-year period. We're not through with the statistics yet for 2004, but that's an extraordinary number given the fact that another circuit, likewise with 12 judges, as First Circuit has, had a little over 1,000, and then the next greatest number was less than 1,000. So
you folks on the First Circuit, you judges, are dealing with almost double the amount of cases.
A little less than that, but it's a great number. And being able to balance the number, the time that's involved in getting those cases out with making sure that they are right is the dilemma that I mentioned.
So what, I know, I think last time we were talking that the First Circuit was trying to get another judge. Is that right or wrong?
Well, actually, we had asked the Supreme Court to consider the possibility of adding 3 judges and weren't successful with that.
What is the rationale?
Well, I don't know, because I don't know the state of mind of the committee that actually looked at that. But I would suppose, you know, a moment ago I mentioned that other states have fewer judges. I suppose that the idea is we have enough judges, we need to
just work harder, huh?
Well, I don't know. And of course, I don't know how we physically could work harder to make sure that the opinions are right.
You were talking about a fella who's up there from 9 a.m. till 10 p.m. every night of the week? 7 days a week?
There's a judge on our court that works 7 days a week. I think it's very common that the judges oftentimes work at nights during the week, and I can't speak for everyone, but I work at least one weekend day each weekend with few exceptions.
So, Judge, what do we do? Is there a way to speed this up? Are there alternatives available? And I know mediation is something that we're going to talk about, but what else can be done?
Well, there's a number of things which could be done. They're all political decisions. That is, they rest with the legislature, increasing the number of judges on the court, which would mean you could deal with more cases annually. You could move some parishes from the First Circuit to other circuits.
Means shifting population?
Yeah, shifting population.
And then I guess there's something that you're not for, but there would be, I guess, revising the amount of review that the appellate court has. As you mentioned, we're the only state in the union that has review of facts, whereas all the other appellate courts of the union have review of only law.
Yeah.
Is that correct? Explain that.
Right. Well, factual review means that, let's suppose, in an oversimplified way, you had a accident at a red light, and a group of people, independent witnesses, said the light was red for the plaintiff, and then you had another person who said, for example, the light was green for the plaintiff. The trial judge determines who to believe and what the truth is. So we actually review that to determine if the trial judge is entitled to accept any view of the facts that he wishes, but just to make sure that his conclusion of the facts isn't controverted by physical evidence. For example, let's suppose that this TV crew were there at the accident and they actually filmed it, and then the trial judge's conclusions didn't compare with the actual film that was taken. We could do something about it. Now, I frankly am in favor of review of the facts, and the reason I say that is because it's my impression that the public is. Any change in that, of course, would have to be by constitutional amendment. So if the public chooses to do that, that would affect it.
Seems highly unlikely, though.
I would think it would be very unlikely.
So what do we do?
As I said, the solutions I mentioned. I might mention the First Circuit has within its jurisdiction the 4 fastest growing parishes in the state. St. Tammany, Tangipahoa Parish, Livingston, and Ascension, and quite a few parishes are growing rapidly. But the First Circuit has roughly 1.4 million people in it, 12 judges. Another 12-judge court has 400,000 people.
Let's talk about the problem on the next segment. This is Locke Meredith with Legal Lines and Judge Jimmy Kuhn with the First Circuit. We'll be right back. Welcome back to Legal Lines with Locke Meredith. I have Judge Jimmy Kuhn with the First Circuit, and we're talking about the appellate court system and how it's basically just overwhelmed at this point almost, and what alternatives do we have. I thought it was really interesting. You said you've done some statistics and calculating and said that there's a decision that has to be made every 0.6 days at the First Circuit.
Yeah, the way we get to this, I took the writs and appeals that were filed. I deducted 104 weekend days per year, and if you do the math to it, it's a judge makes his or her own decision on the cases they're writing every 1.9 days. Which is sort of frightening. I would think you would hope we'd spend a little more time than that on your case. And then when you divide it by the 3 judges on the panel, it's actually 0.6 days. So
amazing. Truly amazing.
Yeah, and that, of course, is why it requires more than an 8-hour workday.
And that's why we want to talk about mediation, because it's an alternative to this long, very thorough process that can take 2, 3, 4 years at times.
Right.
Let's talk about it.
Yeah, be happy to. And of course, the pilot mediation program was an idea. I give primarily Justice John Weimer of the Supreme Court credit for it. He did some studying while he was on the First Circuit of the 5th U.S. Circuit Court of Appeals mediation program.
Which is a federal court.
Federal court, and eventually the state Supreme Court, with Justice Kitty Kimball and Justice Weimer, were able to provide $170,000 for the First Circuit to try this pilot mediation program. I might add that there was some discussion before the mediation program got started to the effect, well, let's speed things up and let the judges of the First Circuit just decide more cases. And of course, that sounds wonderful, but once again, I would ask you, as an attorney practicing law and the people of the First Circuit, do you want us to spend less time on each one of your cases?
Half a day on my case.
The answer is obviously not. That's not a solution to this issue. So pilot mediation came about. The Supreme Court provided the money in the latter part of 2003, and the mediation program began in 2004 in
Let's
February.
define for the folks mediation, because that's a term we hear all the time, but they may not have a clue.
Well, mediation is where the parties to the suit with their attorneys appear before someone who's certified by the Bar Association to help them amicably resolve their lawsuit.
Yeah, I kind of describe it to my clients as, look, the other side's going to be across the table, we'll be on this side, and it's a person who helps us communicate, in essence, walk back and forth. They don't have the power to decide, but they hopefully facilitate communication. Of course, you go up in separate rooms and all that. But
fair description, and of course, initially when the idea was proposed, I wondered how it would work at the appellate court, and I'd like to touch on that in a minute. But most people practicing law, and even some of the litigants, fail to remember this, that at the appellate court, you're not retrying the case. What you're doing is searching for error, and so by the time you get to the appellate court, the case has already been tried, and the lawyers are in a better position to determine how successful they may be in whatever place they are. So frankly, I would think that mediation would be much more successful.
Judge, I got to tell you, I have not thought about that. And really what it does, it's a completely different analysis. And it makes the parties focus on, they shift gears and go from their trial mode to their appellate mode.
Right.
And that's
the likelihood of being successful is extremely more defined at that point, which should make mediation much more successful. Which leads me into the point I wanted to make. We have had roughly 50 cases where the parties agreed to mediate, and have had a 50% success rate.
Which is incredible.
It's incredible because the statistics I've been able to find from across the nation is a typical mediation, regardless of appellate court or before the trial court, is only 40%. And I suggest to you the reason is because the party's in a much better position to determine their chances of success.
I really never in a million years thought that cases would mediate and be successful at that level. When you first told me that, I was blown away.
Well, once again, I think you have to have an attorney who understands the appellate process, as we discussed earlier, and that. We are roughly halfway through with the funds provided by the Supreme Court. And I think what's going to happen is we are going to demonstrate that the program is successful in moving some cases through the appellate court. I hope that the legislature would then make this a permanent program for the First Circuit, and that we could get help from the Supreme Court. The only only change I see, the mediation program is voluntary. The judges on the First Circuit know nothing about which cases were successfully or unsuccessfully mediated, and it's free. I would suggest that we might be able to handle more cases if we could develop a program where a portion of the mediation process is free to the litigants, and part of it's paid by at least those who have been successful in the mediation process, which means you could take the same amount of money and effectively double your the number of cases you could mediate.
Let's describe for the, so basically, and the mediation occurs within 1 month or so of the parties agreeing to do it, and if an agreement is reached, it's over with.
Right, exactly right. You're promised to have the mediation within at least 60 days, but typically it's been within 30 days.
And I think this is important for those of us who have to make this decision, and that is that you guys sitting on the First Circuit don't know who's mediated and who hasn't mediated.
Know nothing about it.
You don't get any of the position papers, don't know any of the facts, aren't involved in the process at all, so it doesn't affect the appeal.
Exactly right.
Another important fact I was reading is that it doesn't delay the appeal process.
Absolutely not. If the litigants want to save money, because I know lawyers charge a fee for writing briefs and appearing for arguments, but the litigants can ask for a 60-day delay, if you will, in the process so that they could work on the mediation. They don't have to, but they may. If you don't ask for the extension, your time delays in the wheels cranking at the First Circuit remain the same.
And so, as I understand it, if you file an appeal at this point, you will receive a letter from the program, Melanie Newcomb-Jones, administrator, and she's going to say, if you want to participate, let us know.
Right.
And at that point, if you say, yes, I want to do it, what happens?
Well, then she contacts, the administrator would contact the two attorneys and work with them to schedule a mediation.
And that they roughly have, what, 60 days to submit the information?
Oh, it's less than that, and that schedule is established by whoever the mediator might be. Likewise, who doesn't report to us, and we're not familiar with what's going on there.
And the mediators that are chosen are local attorneys who have been qualified by the bar.
Qualified attorneys, and they also agree that they won't practice before the First Circuit.
Judge, thank you so much for being on the show
Enjoyed
again.
it.
Appreciate it. It's good seeing you. This is Locke Meredith, Legal Lines, and Judge Jimmy Kuhn with the First Circuit. Thank you for being with us.